holder for those
Thiru,
of you who...
take it away.
Yeah, thanks so much. What a privilege to be here. And what an honor it was to be a clerk. I actually want to spend a minute, though, because I do see some students in the room, reminding people how much a Supreme Court clerkship may not matter. Because I think so much of what we become as lawyers, as adults, as professionals, is defined by things that happened before and after. I am also an immigrant. My family were refugees from Sri Lanka, and we came over when I was 3 years old, escaping a civil war. And my parents got a chance in Baltimore City. My parents were both teachers. My mom retired at a reasonable age. My father taught at a bunch of different schools in Baltimore City and retired as the oldest teacher teaching in the state of Maryland. He was 80 years old. He's 83 now. He doesn't look 83, he doesn't act 83, he doesn't like me telling people he's 83. But that's the tradition in which I was raised. I went to public schools myself, and then I went from some tough schools to Yale for college and Harvard for law school. I was president of the Harvard Law Review before your friend Barack Obama made it cool. And then I devoted myself to public service. And I sometimes think about whether that would have been that different if I had not gone on to clerk for Guido Calabresi and for Justice Breyer. And I'm not sure. I thought I was going to be a law professor, and then while I was clerking for Justice Breyer, we had a case involving school segregation. And naturally, because his father was the lawyer for the San Francisco School Board, and my parents were teachers at some hyper-segregated schools in Baltimore, which was a school like the one I had went to as well, that was naturally the thing I devoted a lot of my time to. And at the end of the year, the plan, so well laid as president of the Harvard Law Review, clerking for Guido Calabresi and for Justice Breyer, to become a law professor was the last thing I wanted to do. And I went to Justice Breyer, and he was so even-handed and even-keeled about what had happened. I was up in arms. I was so apoplectic about the fact that this 5-4 dissent would become the law of the land, and that so much work that he had done was in the words of a dissent. And I said, Justice, I don't want to go become a law professor to write about these things. There's fights to be fought. And he had this reaction. I'm paraphrasing. He said, calm down, calm down. You're here for a year. We do this every year, every year. And he gave me some great advice that helped me define and decide what I wanted to devote my life to. And I think about the lessons I learned. It wasn't just from Justice Breyer. It was from my clerkship with Guido Calabresi as well. And I think the mentorship relationship you form with these judges and justices are perhaps the most important thing. And in that regard, it doesn't matter whether it's a justice or a judge or a law firm partner. There are insights, true wisdom that comes from them. From Judge Calabresi, I remembered a case early on where there's a lawyer from the Justice Department, and they were before the court, and it was an immigration case. The immigrant was pro se. The Justice Department lawyer plainly had the better of the argument. And the question that Judge Calabresi had asked, that Guido had asked, was, counselor, we understand the Justice Department's position, but isn't there another way that this asylum seeker could have gotten asylum? Isn't there another parallel provision? And the lawyer, she said, yes, Your Honor. In fact, I've advised my opponent that he could, in fact, apply if this doesn't prevail through that and perhaps obtain relief. And the judge interrupted and said, can you sit down for just a moment? Can you ask the pro se litigant to come back up? He said, is it true that the Justice Department lawyer actually shared that with you? And he said, yes. He said, you should continue with your appeal, but if I don't get this, there may be a parallel route. And then he called the lawyer back up there, and he said, and it was a very, very early memory of mine with Guido, he said, it's nice to be reminded that you don't work for the Department of Deportation, you don't work for the Department of Convictions, you work for the Department of Justice. And he then wrote a letter of commendation to the Justice Department for what this person had done. And that moment stayed with me, right? And you suddenly realize that even at the level of the Supreme Court, where some of the most controversial issues are being decided every year, the way in which these incredibly thoughtful, brilliant jurists approach the most impassioned issues with a level of dispassion is actually really, really important. That they don't, rewrite the entire Constitution. They don't shout and scream from the rooftops. They find a moment of measure. And when I remembered toiling on this important dissent, even then I knew it was important to the justice, I wrote something that was a screed. And he said to me, no, 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 this will not do. You spend 20 pages writing even-handed history of what happened, no adjectives, no hyperbole, what happened. And then you write 20 pages of even-handed analysis, no exaggeration, no amplification. You say what the law is, and then you can explain why the sky is falling. Because what you've written will persuade the people that are already convinced that you're right. And they will make them very, very angry, but it will convince no one else. And the art of advocacy is convincing people that are on the fence, perhaps even on the other side, that they ought to open up their minds and change. And that was an extraordinary lesson. At that point, I didn't know what I was going to do. I certainly didn't plan on being a prosecutor or now an aspiring politician, but it was an insight that stayed with me for a long time. And then there was a last lesson that I thought was really potent, and I think it's been mentioned a couple of different times. There is a individual humility and an institutional pride that comes with working at such rarefied airs. There is also, and I think the perfect word for it was audacity, there's also a realization that some of the most important things being done in the world are being done by human beings. That the ideas that are hatched by ordinary people. Sometimes 24-year-olds that are a couple years out of law school provide an insight, provide a piece of research, and it changes things. It really can change things and allows you to go off into the world and have a level of confidence that there isn't another room down the hall where the great decisions are being made, that oftentimes you are in that room and you are expected to be that person. And that, I think, has been very, very powerful for me. I'll end perhaps with a story that's both about Baltimore and about how little value a Supreme Court clerkship can have. President Obama didn't waste any time with these Supreme Court clerkships. The other person that didn't do that was a young man from Baltimore named Thurgood Marshall. He went to Frederick Douglass High School, where my father had taught many moons ago. And he then went to Lincoln University and desperately wanted to go to the flagship law school in his home city, the University of Maryland Law School. But of course, back then, blacks were not admitted. So went down to Howard Law School, and he started studying. And he was discovered by the dean of Howard Law School, Charles Hamilton Houston. Dean Houston was actually the first African-American editor admitted to the Harvard Law Review. So his portrait is the only portrait that sits in the Law Review building. Not Barack Obama, not all of the Supreme Court justices, just Charles Hamilton Houston. And it wasn't because he was the first African-American editor. It's because he discovered Thurgood Marshall. And as a dean, he saw this 1L student who was so brusque and so brilliant, a better oralist, advocate, writer he had never seen, and he mentored him. And he graduated at the top of his class, and he could have gone to any law firm, any clerkship that he wanted to, but instead he went back to Baltimore. And fresh out of law school, he hung up a shingle on a Redwood Street, right downtown, and in his first year, he filed a lawsuit against the University of Maryland Law School for not admitting blacks. He made an argument no one had ever made before. He made an argument no court had ever accepted before, and he won. The University of Maryland Law School became the first graduate program desegregated by an order of the court by Maryland's highest court. And the same argument, a kernel of it at least, that he made in 1932, he made 20 years later when he argued Brown versus Board of Education before the United States Supreme Court, where he changed anything. For me, I am proud of the fact that that kid's from Baltimore. But it's also a reminder that that audacity, that confidence, that you can make an argument no one's ever made before, doesn't require you to clerk on the Supreme Court. It requires you to appreciate that the power of the law and the power of advocacy and the power of insights we saw, day after day at the court, but that lives and breathes in advocacy and in courtrooms and in law schools everywhere.
Well, that was just so stirring that I'd feel silly trying to add to it or improve it. And I know that we're coming.